Hey guys, Raees Mohamed here from RM Warner Law, and we're going to go live here with our buddy Robert from Santa Monica talking about the Bang Energy lawsuits. There's a series of lawsuits. We want to talk about the implications of them. Bang Energy lawsuits. Let's see here. Yes, if you guys have been paying attention to what's happening in the social media music world, the copyright world, Bang Energy getting sued left and right for copyright infringement for the use of music in influencers' content. I'm just waiting for Robert to join here any second. Robert,
Hey,
how are you?
I'm doing well. How are you?
I'm good. How's are you guys getting a heat spell in Santa Monica?
It's a little warmer this weekend than it's been the last week or so. Not too bad though.
Yeah, not 114.
Right, not anywhere close to that, thankfully.
Um, it's good as always. It's been a while since we've last done one of these, so I figured it'd be a good time to chat about some things that you and I both have been following on the social media world and infringement and influencers and the use of content.
hmm
Um, and you had posted recently about Sony Music suing Bang Energy.
Right.
And, there's been some updates in that litigation. There's been some rulings on summary judgment, partial rulings. And I figured we could just kind of break that down a little bit. And then obviously, some of our viewers know, some of them don't know that UMG Recordings, Universal, filed their own lawsuit against Bang Energy. And interestingly enough, it's the same judge in both
Right.
cases.
Yeah.
And there's some serious implications on, there's some evidentiary issues, right? So in layman's terms, there's accusations that Bang Energy is actually hiding stuff. They're deleting evidence. And the whole way that Bang Energy handled this is pretty egregious, right? From a lawyer's perspective, when you look at what happens pre-litigation, right? So parties
Yeah.
are talking, the demands being made, and these are juggernaut entities, right? I don't know how big. I don't recall how big Bang Energy is in revenue size, but they're the top. They're like in the top three energy drink companies. Period.
Yeah. And very litigious too. I mean, they have an ongoing war with Monster Energy and a bunch of other companies, and apparently they have a very large litigation budget and don't mind spending to see things all the way through. So obviously business is pretty good if you're Bang Energy, but I agree with you that the way that this was handled pre-litigation, I don't know if reckless is the right word, but certainly not what I advise a client to do in response to the sorts of demands that UMG and Sony were making. And both of those companies I identified and noted in their complaints that part of the reason we're initiating the suit is because other companies have licensing agreements with us, and you were the one that decided to tell us to go shove it when we identified this issue and forced us to litigate it. And yeah, I realized after I had posted about the Sony case that I had switched UMG and Sony. So the rulings were in the UMG case. The
That's right.
Sony summary judgment motion is pending right now. I expect same judge, essentially the same facts. You're going to get more or less the same ruling, and it is interesting from the standpoint of it directly addresses a question that comes up all the time in terms of what can and can't we being a brand or an influencer use with music on TikTok, and then also this issue of potentially the influencer posts constitute vicarious infringement. And to me, that also means that if UMG or Sony were so motivated, they could have brought suits directly against the influencers for direct infringement because it's the same activity and essentially the same conduct. So it's nice from my perspective that now I can actually point to a ruling and not just give my opinion about what's okay and what isn't okay with respect to using popular music on TikTok as part of influencer campaigns.
Yeah, no, well said. And one of the scary things, just to go back to, is, Bang Energy, again, sophisticated, large institutional client. If they're your client, they have in-house counsel. They've got a team of lawyers. Presumably, they would have outside counsel vet some of these things, but they have a heavy IP department, right? At least this litigation has demonstrated they have multiple tiers of lawyers. There's people at the top level looking at these things, and I've fortunately been able to, and you probably have too, have actually seen Bang's influencer agreements, at least in the last few years. They may have changed it recently. But they take the position that any influencer that is being paid and signing this contract, that they're assigning all the rights to Bang, right? So it's Bang's content unequivocally. But they also, they kind of also say that, hey, influencer, you will not infringe on anybody's content, right?
Right.
And so one of the implications, you're right, that particularly IP lawyers are looking at is, hey, when I get a contract like this, if I negotiated this out and say, no, I'm going to scratch this out, and say, I can't, in light of this ruling, I can't actually say that this is going to be non-infringing. I don't think that works still, right? In other words, I think influencers are always going to be exposed to liability for using infringing content, period. I mean,
yeah, absolutely. I mean, the contract is, it would address a situation between Bang and its influencers and potentially an indemnification type of situation. But as far as UMG and Sony are concerned, it doesn't really matter what the influencer has agreed to with Bang, except to the extent that UMG was trying to use that agreement to show that for purposes of vicarious infringement, Bang has enough control over what its influencers are doing that they meet the element of control such that you have that claim. And the court said, well, you've alleged it enough, but we can't say at summary judgment whether or not that's true, and that's an issue of fact reserved for trial. But they're not saying that contract for sure means that Bang is liable, but that it's UMG's way of using that agreement against Bang in a way that the court at least thought was plausible and deserves to go to trial. So, but to address your point, yeah, it doesn't get the influencer sort of off the hook, even if Bang says, we promise that every sound clip we suggest that you use it won't infringe, or the other way. At the end of the day, it's on both of you essentially to make sure that that's the case. And then when a situation happens, that contract can sort of guide how, between the various defendants, as the case may be, that liability is apportioned.
I thought it was super interesting. Again, I don't think that large or small businesses generally appreciate the critical nature of doing business online, right? This is our domain. Like, this is our niche. And we're constantly reminding people, listen, if your business is important, you need to really pay attention to this. You really need to pay attention to exposure. Don't use template contracts. Seek legal counsel. Seek legal counsel who works in the trenches of this stuff. People like you and I, we're looking at these things on a day-to-day basis, but I couldn't help but look at this. And I'm looking at the ruling from the UMG case on the summary judgment. And for those of you non-lawyers who are going to listen to this, summary judgment, you have citations to the record, although it would appear that Bang Energy's counsel did not make many references to facts and had multiple attempts to come up with facts that were disputed. I digress. It's really interesting in the rulings because the judge cites to the record, and you will see, we get a chance to see both parties' versions of the facts, but in fact, they agree that certain facts are not in dispute, right? Mm-hmm. And some of these facts are pretty egregious. And just starting from the top, I mean, yeah, nobody's disputing that Bang considers all of its influencer videos to be ads for Bang, period.
Right. Yeah.
Interestingly enough, and you would think that this is, hey, Bang is smart. They have a social media team that audits Bang influencer videos, including the music that plays with the videos before the videos are posted. They have a team that's supposed to be screening this. Okay, strike number 2. Strike number 3, as a condition for payment by Bang, they're instructed to submit the videos to Bang's auditing team with links to any of this music, and its auditing team has responsibility to ensure that Bang's influencer videos conform with Bang's social media guidelines.
Right.
So, I mean, so far we're scratching our heads like, okay, guys, you have all these policing methods. This is the one that's kind of crazy. The social media guidelines are the only policies and procedures for evaluating Bang's influencer videos. In the guidelines, Bang sets forth the rules for what influencers must include in their videos, including consuming products on camera, ensuring the logo is facing the camera, right? The whole idea being they're very, very detailed. The element of control that you were just talking about. What to wear even. They're telling the influencers what to wear. They're also required to tag Bang, right, in all of their drinks in order to, all of their content to get compensated.
Yep.
And the owner, the CEO, Jack Owick, specifically said, it, according to the ruling, that it's really important, in direct quotes, to Bang, that Bang influencers tag Bang and Jack in their videos so that they stay relevant with their fans.
Right.
Now, here comes some really super interesting facts, just kind of fast-forwarding things. I guess it's the owner's wife, Meg, who's the senior director of marketing at Bang, right? That's my understanding. They're the only people who approved the 2019 guidelines, which are the guidelines at issue today, the Bang guideline.
Right.
The 2020, the 2021, and 2022, the guidelines for Bang do not prohibit the use of copyrighted music on TikTok. I mean, what is happening here? What is going on?
Yeah,
right?
It is a mystery. It's like you have all these requirements that everything is audited and screened for compliance and all of this, but if at the end of the day you're not screening for the issues that could potentially expose you to liability, then what's the point of all of this? And
I think, to me, and Meg is the one, you know, just background, she was a cheerleader, you know, and she met the founder of Bang Energy Drinks through Facebook by like she used to tag him in her videos to promote, right? Because she was, and that's a little history for everybody. That's kind of, I think, how the whole influencer concept grew Bang Energy. That's my understanding, at least. That's how that blossomed. But interesting thing is, according to the summary judgment motion, this is an order the judge entered after reviewing the facts. Megan did not ask Bang's in-house legal team if Bang could use copyrighted music in its TikTok videos until after the lawsuit happened.
Yeah, I mean it's so hard to believe. Like, I guess nothing really surprises me anymore, but like, even if that's the case, Bang has an in-house team that I imagine is pretty sizable. Every Bang influencer piece of content that I've ever seen, whether I'm out there looking for it or not, I mean, they do a good job of awareness. I organically see Bang influencer content all the time, and every single one I've seen, I thought, like, who on their in-house team is responsible for this? Because they must know that what they're doing is not compliant with the law. It's so flagrant. So the idea that, like, their in-house team is reviewing this and then giving the okay and actually trying to apply the law to their campaigns is clearly not the case. So one possibility is that their campaigns are so successful and drive so many of their sales that they figure, okay, when these challenges come, we'll hold things up in the court for a year or longer, and then if we have to pay whatever it is, that might be a fraction of what we made by just violating, just by ignoring it the entire time. Which is probably the case because, they're a sophisticated entity and they make a ton of money. So I think that it's a cost of doing business as far as they're concerned. Now, Bang's in a position to do that, probably, but a lot of businesses could face potentially the same statutory damages for the same sorts of campaigns. And if you don't have that kind of war chest, it could put you out of business potentially. One thing, and going back to like the follies, right? So we just talked about a series of missteps in terms of the policing aspect. Now let's bring in the lawyers, right? So my understanding, according to this order, December 3rd, 2020, in-house counsel for plaintiffs at UMG, Gideon Eckhouse, in-house counsel for plaintiffs told Gideon, who's Bang's chief counsel for IP, in an email that, hey, we'd love to sort out the attached
unauthorized uses of content on TikTok. The parties don't disagree that that email was sent, right, for our
Right.
viewers. 6 days later, plaintiff's in-house counsel sends an email saying, you need to preserve evidence. So now,
Yes.
hey, let's sort this out. Next step, preservation. Unfortunately, counsel for Bang made no attempt, even at that time, to determine whether Bang had a license.
Right.
Even.
Right.
I mean, this is like seriously egregious. Instead, he responded and told UMG that, quote, my understanding is that TikTok provides use of these songs and others with a license to all of its members. Let's stop right there.
Mm-hmm.
If anybody just went and read the TikTok ad terms, you would see commercial, royalty free, and you would see like non-commercial. In other words, this is what you can use to promote, period. Yeah. Like, and you don't have to be an attorney to understand that there are terms that apply to commercial use.
Yeah, I'd say TikTok did a pretty good job and better than some other platforms of explaining it. And they'll set it out in sort of legalese, and then they take the time in subsequent paragraphs to say, like, here's what we mean by this. Like, here's an example. So the idea that somebody could, especially Bang's in-house team, could in good faith write back, well, we thought TikTok gave us the license to do that. It's preposterous. It really is. Now, adding more fuel to this fire, this is just mind-boggling, right? And I think, by the way, hats off to UMG's counsel for really articulating the egregiousness of the conduct. And the facts are the facts, right? As lawyers, we don't make up the facts. We have the facts and tools and we paint them. But you probably read this too, but you know that guy on TikTok, Q Park, right? He's got like 30 million followers on TikTok. He does those. It's so strange. He just dances in public and makes a fool of himself. So 5 months after the litigation starts, Q Park's videos, he's a big influencer for Bang, probably the biggest. He submits his videos again with copyright protected video audio. Yeah. And Bang passes it through. Yeah. They don't even check against they actually have actual knowledge and a list, and they have actual knowledge of TikTok's terms. They don't check that? Yeah, I mean, there's so much that's like bewildering about what happened before and during the case that, I mean, they're a very brazen entity when it comes to taking lawsuits seriously and how they conduct themselves in litigation. And this part, it's not always lawyers oftentimes are after the fact people. We clean up people's messes. In this instance, you at least have in-house counsel who was part of this pre-litigation, during litigation, and after all these proceedings. Who knows what they've changed internally as a result? Yeah. I do know Q Park's not using Bang Energy. I don't know if you've been on his page anymore recently, but he's using some other energy drink to promote. Do you know what happened with that? I don't know much about that, but I mean, it's probably a good move for his sake. I mean, who wants to be further embroiled in this as it goes to trial, as somebody is continuing to post exactly the type of content that's at issue in the case in the first place? So, yeah, if I were an influencer that, subject to whatever the contract is that you have with them, if there's an avenue to not continue to post while these cases are progressing, I would certainly not want to get myself any more involved than I have to. So yeah. I can totally understand not wanting to do that, at least for the time being, while these cases sort themselves out. I think my guess is Q Park has really good counsel, and they were probably like, stay the hell away from Bang until this sorts out. Keep your thing going. You have viewers. You have 30 million viewers watch this guy make a fool of himself in public drinking energy drinks. It's like the most amazing thing in the world. Yeah. So obviously the overarching case is still in existence. The issue of infringement, there's a ruling now on summary judgment that you absolutely infringed. And now there's a question about whether they could win at trial as to vicarious liability for influencers, right? Right. And then the damages issue for the direct infringement. Yeah. And I don't know about you, but
I think that statutory damages in this case are going to be significant.
Oh yeah.
I think their conduct was willful. It was wanton, as we say. It was reckless. It was with knowledge. And for people listening, like, whether you have knowledge of like, there's no knowing or unknowing. You're presumed to have knowledge. It's kind of like automatically you're liable. The question of damages is where the correlation between knowledge and recklessness comes in, right?
Right.
What do we think is going to happen in the world of influencers' use of music on TikTok? I mean, what is going to happen as a result of this?
Well, what I'd like to see happen is that there's more education and information around what is okay and what isn't, and hopefully it will motivate both brands and influencers to pay more attention to the general topic of what type of content is all right and is not all right to use on various social media platforms. I also hope that it will cause influencers to want to take closer looks at their agreements with brands, because it's so common to just be presented with a contract and you assume that because the brand put it together, it's done professionally and it's fair, especially if it's a big company, and you can sign it and just get to the work of creating content. But there's so many instances that I've seen from sophisticated and unsophisticated entities that will present contracts to influencers that are just not only a little bit advantageous to the brand, but just patently unfair. And you can sign something that affects your career as a creator going forward inadvertently. So I hope that this would encourage or motivate creators to really take a look at their contracts. And if there's anything that they don't understand, have a professional take a look and help you understand it before you sign it, because you can really get yourself in a tough situation inadvertently if you just assume, oh, this is probably boilerplate, this, probably every agreement says this, and maybe you don't have a full grasp of the full range of implications that might have on you.
You know, the only reason, my understanding is the only reason, or one of the most significant reasons, the judge did not grant summary judgment in favor of UMG on this exact issue, and I'm looking at the ruling right now, is that Bang had argued, and this is interesting, that even if it was true that Bang has these policies, Bang approves, like you contractually bind these guys, that the contributory infringement claim fails because Bang at least had some evidence that the defendants have no part in the production of the video, and they don't have any input regarding the music selection. And the judge says that, quote, plaintiffs do not meaningfully respond to this argument in that context, and then that they conflated vicarious liability theories, right? You know, that's an interesting point. So basically, to get down to brass tacks, if you're hiring an influencer, you have the contract in place, but you don't select, you don't procure the music, you don't help produce it, you're not an agency, right? You're not in the production business. There's an argument that you shouldn't be held vicariously liable, or you can't be.
Yeah. But, you know, if I were looking at this with the goal of trying to avoid liability for that by taking sort of like a hands-off approach, or maybe borrowing that argument so that I can have influencers use music and sort of get away with it, that's not really a safe place to land, because as we've seen, you'll at least survive a pleadings challenge. And potentially, you know, this is just one judge looking at it in one case, well, two cases, but same judge. The way cases turn out is frequently so judge dependent. A different judge could have looked at those facts differently, maybe with the help of the clerk, and come out differently. But even here, you know, you're through summary judgment on this issue. So it would be a mistake to think like, oh, well, Bang's in the clear and maybe we should just use influencers and then we can say, hey, they're creating the content and we have no say in it. That's not the kind of thing I would want to have to convince a jury of after years of litigating the issue.
You know, I have a feeling that these cases are going to start a wave of enforcement actions. And I hope that people who are in the content development business, content marketing business, and who are influencers and the like, pay attention to this stuff. and learn that, number one, just because you're a big juggernaut guy on the block doesn't mean you're doing it correctly, as you said earlier. Number two, you should speak with your own counsel. Don't rely on Bang or whatever endorsement company is handing you this document. Understand what your obligations are. Understand, for example, what are the FTC rules? What does U.S. copyright law say, right? And talk to somebody who lives in this world and can give you advice on the do's and don'ts. And that way you can tell Bang, you know what? I need out of your contract. And this is, we haven't talked about this, but Bang has been notorious for not allowing people out of their contracts either, and having very, very sharky methods of keeping people in their contracts. And maybe this will allow people to get out, right? As these rulings are coming up saying, hey, illegality, like I can't, I'm going to refuse to do this because I'm going to be responsible. You guys approved my prior videos and you didn't, even after the lawsuit, right? Q Park would have a potential good lawsuit maybe. Yeah. For maybe an equitable indemnification, right? Some of that theory exists in some states to say, you know what? I know that I'm supposed to indemnify you, but you guys misled me. You approved this. You had actual knowledge that it was infringing. Now you should indemnify me, and I'm gonna come after you for my fees or whatever, etc. Damages. So lots of interesting stuff, man. I don't know that we know what the next briefing is or when this case is supposed to go to trial, the UMG case in particular. But I know you're watching this case. We're watching it, and it'll be interesting to see how this turns out.
Yeah, definitely. I mean, each step has been interesting so far, and I hope that, you know, it seems like these parties are pretty motivated to see it through. So in these sorts of things, I do like to see them go to trial so we can actually get a ruling on things. I hope they don't settle the night before so that we can get some closure on all these issues. But who knows? You know, that's the long shot. Probably it will settle, but we'll see.
You know, I think Bang's CEO, I'm not a huge fan. I don't know if you've seen some of his videos. It's so cringeworthy. People who are watching this need to go watch some of his TikTok videos, his personal videos. He's if that were my client, I would not call him to testify. Unfortunately, they don't have a choice because he's a direct participant in this.
Yeah.
What a nightmare. What a nightmare for Bang.
Yeah.
Well, good, man. Well, this is great. How's the accident, by the way? I have to ask. Anything new?
I've got a year left with it. The air conditioning broke, so that's going that's going in on Monday to get fixed. But other than that, you know, it's been great to me. I love the car, and yeah, we'll see if I can. I'd love to just keep it and sort of run a new lease on it, but we'll see in a year what happens.
All right, man. Well, it's great to talk with you as always, Robert, and we'll be in touch, and hopefully we have some more updates for our viewers on this case.
Yeah, this was fun. Thanks for inviting me again.
Hey, thanks a lot. Take care.
You too.
Bye.